Good morning, everyone. Welcome to today's ChiefPricingOfficer.com members only session with special audience attendees from the legal community. We're fortunate to have with us Gene Zelek, someone that I've admired for years as the foremost authority on pricing law. He's one of the most entertaining lawyers you'll ever hear. And yes, I know that sounds a bit like an oxymoron, entertaining and lawyer. But if you've ever seen his slides, you know that Gene has a knack for making tough technical topics surprisingly approachable and memorable. That's why today is such a gift. We're going to hear from someone with decades of experience guiding the world's top brands through the most sensitive legal questions and pricing, but in a way that's actually engaging and even fun. So let's have some fun. For the sake of audio quality, all participants will be muted, but Gene welcomes your questions. Just drop them into the chat throughout the presentation and we'll bring them up as we go. So with that, please join me in welcoming Gene Zelek. Gene?
Well, thank you, John. I hope I live up to the billing. In any event, we should just jump in. Welcome to everybody, and I look forward to this. I look forward to your participation. Go ahead, John. Go to the next one.
Okay.
Now, this is just a quick note that says that we may be talking about things of competitive significance, and as a group, we're not advocating any particular approach or whatever, but it's really up to everybody to make independent decisions. So in other words, the purpose of this is not to get everybody doing the same thing at the same time, particularly if they compete with each other. Next. So our topics, and you have to excuse the hyperbole in the lower right-hand corner. I think this is hot stuff. It's certainly topical. You may think it doesn't quite have the immediacy, but I do this for a living, so I have to make it sound good. In any event, what we're going to talk about today are some issues that lots of businesses and their lawyers avoid, but we're going to go right at them. And the first one is price signaling. The second is the use of third parties in algorithmic pricing, including AI. Third is resale price setting. The fourth is account-specific pricing in both of its modes, price discrimination, promotional discrimination. Next, because of time, we're necessarily kind of doing a survey, and we really don't have a lot of time to get deeply into the topics. In fact, there's a whole bunch of other things that are pretty hot right now, too, that we'll leave for another day, such as information sharing, benchmarking being one of them, standard information sharing being another, most favored nations clauses, revenue growth management, predatory pricing, customized or dynamic pricing. There's often an AI element there, global pricing, and anything else that you are interested in. Next. So to set the stage, when we talk about price signaling, our first topic, you have to really think about competition, and I think sometimes this gets lost in the discussions, but the essence of competition as a company, you either lead, you follow what others are doing, or you don't do anything, one or the other. Next. And what that requires is you need information upon which to make the decisions whether to lead, follow, or do nothing. And one source of information, go ahead, next, is signaling. And the truth is, even though it seems to be a very pejorative term, and lots of people, particularly lawyers, kind of get the heebie-jeebies every time they hear it, everyone signals all the time. Every time a company takes action in the market or doesn't take action, it's sending a message out to the marketplace. And needless to say, most companies send out lots and lots of messages all the time, and their competitors and others are out there trying to read the tea leaves and figure out what's going on. So as an example, in a famous situation, a company that had excess inventory decided to drop prices. And it did just that, it dropped prices. Well, its competitors, reading the tea leaves, thought that what the company was doing was taking an overall price decrease. And therefore, a price war was ignited. And they wound up fighting it out, where in reality, it was only temporary to get rid of some of this excess inventory. Had the manufacturer that did it let people know, hey, this is a temporary price reduction to clear some inventory or whatever, it would not have resulted in that. So what I'm proposing, go to the next slide, please, is strategic price management. And this is where you take a more active involvement in controlling the messages that both you receive and that you give out. So from an offensive point of view, it would be controlling the outgoing signals. And from a defensive point of view, responses to incoming signals, because obviously there's a lot of noise too out there and sifting through it. Obviously there's an interface not only between the pricing function, but between competitive intelligence and these kinds of things too, and sometimes gets elevated to a very high level. In any event, so by strategically managing price or its messaging, one of the key components of that is signaling. Next slide. So what's signaling? Signaling is overt communication or explanation of future, contemporaneous, or previous direct or indirect pricing actions with the intent that competitors receive such information. So it's intentionally sending messages out that you control with the intent that your competitors receive it and act on it one way or another. Next slide. So the law that we have to worry about, clearly there are antitrust implications associated with this, is Section 1 of the Sherman Act. And the key language is that which is highlighted in red. You need a contract, combination, or conspiracy for the law even to apply. The language obviously is very broad. Every contract, combination, or conspiracy in restraint of trade is hereby declared to be illegal. But you need a contract, combination, or conspiracy. What that means by definition is you've got to have some kind of agreement present. So if there is no agreement, Section 1 of the Sherman Act, the principal anti-price fixing statute, simply does not apply. And most states follow the same thing in their state statutes. So avoiding a contract, combination, conspiracy is the key. This will come up later in another context. So from a legal point of view then, when there's some activity going on, like signaling, how's it analyzed? So if there is, it's clearly there's an agreement. The parties have met in a smoke-filled room and they exchange information or whatever, that's one thing. Or if there's a written contract that says they'll do certain things, that's one thing. But most often, of course, those things don't exist. So the law has to see, is there really a contract, and looks at a couple of factors. Go ahead, John. The first is conscious parallelism. And this is parallel behavior. So are companies moving in tandem? Are they doing the same kind of thing? Now, interestingly, conscious parallelism alone is not illegal. Not illegal by any means. Go back to that, or when we think about that earlier slide about the essence of competition is to lead, follow, or get out of the way. Well, following is perfectly rational behavior in many cases. I mean, think of the situation where you've got two gas stations on opposite corners, and one raises the price by 5 cents a gallon. And the other one looks at it and says, oh, well, I should raise my price by 5 cents a gallon, and does that. That's conscious parallelism, and that's not illegal. That's absolutely not illegal. So, but one of the elements to prove an agreement is this parallel behavior. Next slide. And then you need something called plus factors. And the plus factors are digging into what's going on here. Is there evidence of direct communication between the parties? Did one gas station owner call up the other one and say, hey, John, I'm thinking about raising the price by a nickel. How do you feel about it? Are there incriminating statements where people say certain things that indicate something is going on that's untoward? I'll give you an example of I guess it was an incriminating statement, but there was a situation where a president of an association of appliance manufacturers stood up at a big industry meeting and said, now I can't tell you what to do with your pricing. That's up to you. But this whole industry would be better off if everybody took their price up by 5%. Well, lo and behold, within the next week or so, everybody in the industry went up by 5%. That was an invitation followed by action. So you have to be really careful about that kind of stuff. Unlikely contact, people doing things that they normally wouldn't do. And I guess the last element sort of ties into the previous one, behavior that's contrary to self-interest. Are they doing something that it hurts them in the short run, but is consistent with doing something, evidence of a conspiracy that benefits the whole group or whatever. So you really have to sort of dig into these things. Well, you know, what does that mean for signaling? Next slide. The law is very interesting. There's a great case from 1984 involving manufacturers of tetraethyl lead, which is the stuff that goes into leaded gasoline. And a case is widely called DuPont. and the FTC challenged the practice of the parties signal each other by doing things like advance notice of price increases and various other kinds of things. And these chemical manufacturers, by the way, sold to refiners who put it in the gasoline. In any event, the FTC thought this was the end of life as we know it. It's terrible and everything else. The appellate court reversed the FTC's decision. And this is what essentially has come out of it. It's perfectly okay to communicate with stakeholders, but your message has to be appropriate to them, and the communication has to be directed to the stakeholders. So in other words, it doesn't matter if your competitors pick up some of the language or some things that you've done in communicating with stakeholders. So the idea is direct the message to them. Next slide. Well, who are stakeholders? There's simply, if you use intermediaries, they're wholesalers, distributors, dealers, retailers, or others. They're your ultimate customers, they're employees, they're investors. All these people are appropriate audience for you to talk about pricing decisions and to explain things, knowing full well that your competitors will have access to this stuff. That's perfectly okay. So to give an example of some real life situations we worked on, we work with a leading manufacturer of building materials. It was number one in its particular segment, no question about it. And what had happened historically is that all it and its competitors, every time business was good, and being in the construction materials area, it obviously was cyclical. Every time business was good, everybody invested in capacity. We're going to make more of this stuff. We're going to make more money. But the problem was, of course, when there was a downturn, they were stuck with all this excess capacity. It was a real albatross. So the company wanted to change industry behavior and get everybody off those kinds of cycles. So we orchestrated something where they made an announcement to their dealers, to their ultimate customers, to their employees, saying, look, historically, this is what we've done. Now, we tailored the message carefully to talk about just what we did. We didn't talk about the rest of the industry, but we talk about what we did. Historically, this is what we've done. Well, we're not going to do this anymore. We're going to take a price increase instead, and we'll just live with the capacity that we have. So we put it out there and then held our breath. And within a week, all the key competitors put out similar announcements. So we succeeded in changing industry conduct in that respect. And it was perfectly lawful the way that we did it. Another one is we worked with a company that was one of two providers of services in this particular industry, but there were a gazillion customers. And the customers were very smart. They would play one of the vendors off the other all the time by saying, oh, well, these guys promised me this and these guys promised me that, you know, whatever it was. So what we did is kind of a form of signaling. We changed things by becoming transparent in the terms we were doing. So when we reached a deal with somebody, we would announce what the terms were. And that took away our competitors' ability, or I should say, the ability of the customers to play one off against the other, because now it was transparent in terms of what we were doing. So we introduced transparency, and that worked without a charm and without being challenged. The final one is one of my favorite. It involved elevators. And I didn't know this before I started working with the company, but there is no such thing as a standard elevator. And I guess that makes sense because it depends on the size of the cab, the speed, the height of the building, and all kinds of other stuff. Capacity, I suppose, another one. And so in an industry like that, where everything is customized, how do you signal to your competitors that you're taking a price increase? Well, what this company did was it put on its website a theoretical elevator. 4 stories, certain size cab, this, that, or the other thing. And when it wanted to communicate a price increase, it increased the price on the theoretical elevator, thereby signaling it was taking a price increase. Also very successful. So common vehicles to communicate with your stakeholders, certainly email, websites, text, social media, old-fashioned letters, speeches and interviews like the trade press or whatever, public filings, and meetings with investment analysts. All these are legitimate ways. So remember that the key is you have to have a message that is appropriate for your stakeholders. It's directed at the stakeholders. You don't say anything about your competitors, but you put information in there that you know your competitors are going to pick up. Now, they may not apply it in the way you want. They may not do what you think you'd like them to do, but this is a way where you can communicate indirectly with them, and it's perfectly lawful. Next slide, please. Sort of a variation on this theme is using third parties. So there's no question that if I can do investigations as a company and see what my competitors are doing, look across the street at the other gas station, or send people into the store to see what shelf prices are, or order product or whatever, there's no question I can use third parties to do the same kind of thing. There's also no question that I can use syndicated data from Nielsen or Polk or others that give me useful information. A step up on that is information pooling, where competitors come together and they put their information together. This is a whole separate topic. We could easily spend a day on it. So unfortunately, I have to give this fairly short shrift, but there's been a lot of publicity lately and a lot of cases filed with against third parties and the people who work with them. One is in the housing area, like apartment rental. Another one has been in the meat industry, where they pool data. A lot of it is public, but some of it is private. And then this third party will, using an algorithm or whatever, will make recommendations in terms of what the price should be or other kinds of factors. And the government's been attacking those. So far, they've not been very successful. A bunch of them have been dismissed. There have been some settlements. In fact, Tyson just yesterday or the day before settled out for, I think, $85 million in a pork price fixing conspiracy that supposedly used a third party and whatever. Just because somebody settles out doesn't necessarily mean that they had liability, but they probably viewed it as a least cost option. But maybe there were some other things going on. All the standards we talked about how you have to infer an agreement is really important here. So you can have, now let's talk about algorithmic pricing specifically. You can't have an outright conspiracy. One of my favorite cases, which is now about 5 years old, involves some people selling posters online. And they clearly met in a smoke-filled room and said, let's all use the same algorithm and let's all price the same way. And they were found guilty of a conspiracy. There's no question about it. But others, like these ones that I've been talking about in the meat industry and apartments or whatever, what the plaintiffs are trying to show is a hub and spoke conspiracy. And a hub and spoke conspiracy is the hub is the information provider and the information gatherer. So it's the center of the wheel, such as in the illustration. The spokes are the various members that are contributing information and then getting it back. But the problem is, in order to have liability, you need an agreement. And what's often missing in these cases, there's no proof that there's a rim around the wheel, meaning that there's an agreement among the parties that they're all going to follow what's recommended. When that's not present, you've got no case. And we're seeing that in a bunch of cases that have been dismissed. In any event, to me, this is a fascinating topic. Information sharing in general, which I've done a great deal of, is fascinating. Unfortunately, we just don't have time. We need to move on to the next topic, John. Excuse me. So let's talk about resale price. And I like to think of this diagram. It's one of my favorite. It talks about the stakes. So in the diagram, we have the suggested resale price, which if everything of this particular product were sold at the suggested price, the revenue would be $90 million. But nobody pays the suggested resale price. There's an average resale price, which is $63 million. To get there, then, you take a look at what I call the pie, which is the total value that's available. And that is, in that $63 million, that is the revenue from the sales to end users. Let's keep the analogy simple and assume there's just one reseller involved. So the manufacturer sells to a dealer, distributor, retailer, whatever, who then resells. So in that $63 million, that's the total revenue that comes from the end users. That's effectively split between the reseller and the manufacturer. And we're going to come back to this concept in a minute, but when I talk about the pie, I talk about total value. So it behooves the manufacturer to keep that resale price up as high as the market will bear. Why? Because then there's simply a bigger pie to split. And there may be some other reasons too, such as positioning of the product. Maybe it's a premium product and therefore should command a premium price. There may be other considerations associated with it. But for now, we'll just talk about the pie, the total value. Next slide. So one of the things going on, particularly as the internet has evolved in e-commerce, and I know we have a diverse audience, so we're not going to talk about people that sell consumer goods. We're talking about people that sell business products too. And for those of you that are service providers, unless you're using resellers that take title and then resell for their own account, this stuff is probably not as applicable to you as is the price signaling. In any event, because of the rise of e-commerce, it's really thrown a monkey wrench in a lot of things and changed the way people sell greatly. And as a result, historically, we've had traditional sellers that say, wait a minute, we can't make money anymore because people keep undercutting us. So they go back to the manufacturer and they say, either lower my buy price so that I can maintain my margin, or give me more in trade spending so that at the end of the day, my margin is preserved. And they threaten to drop brands with insufficient margin, or they're going to go to private label because they make more money on that. And then dealing with online resellers, they're often very pushy, to say the least. And one of the things that we've seen, for example, that definitely reseller driven, you've got companies like Amazon and Target that are demanding that manufacturers sign minimum margin agreements. So you have to guarantee them a margin. They may choose to discount, but if it falls below the magic margin, you have to make up the difference as a manufacturer. And then there are other online resellers like Grainger that are very aggressive too in the B2B segment. Any event, so this corrosive channel conflict where you get some online sellers typically that often have a much lower cost of doing business than the traditional brick and mortar ones do. They use that to their advantage, and they drive the market crazy. And that results in resale price erosion. The price keeps going down, so the pie is shrinking rather than being stable or growing. Next slide. So there's several ways to fight resale price erosion, and you can selectively raise buy prices by channel. You can differentiate your products by channel. You can silo products. Some BAMO stands for bricks and mortar only. You can control distribution better. You can have price discussions up to a point. And you can just simply get rid of discounters because you're not required to deal with everybody. But the thing we're going to focus on are minimum pricing programs. They're either done by agreements or unilateral policies. Next slide. So what's the difference between an agreement and a unilateral policy? An agreement requires approval from the other side to implement or change. So they've got to agree that they're going to go along with this. And then every time you make a change, unless the original agreement allows for it, you have to get their approval. Now, what's wrong with this picture? It gives one particular reseller veto power, and not so good. Far better are unilateral policies. And unilateral policies are announcements that can be adopted or changed anytime. So they're the essence of flexibility. So you can change them anytime you feel like it. You don't need agreement from the other side. Just say, hey, this is the way it's going to be. Now, there are some conflicts implicit in taking this approach, but most of our clients, quite frankly, ignore them. I can drill down on this later, but let's go to the next slide. So in the area of minimum pricing, there are two forms, essentially. The one is something most people don't talk about, and that is minimum resale or resale price, something I call MRP. And this means the manufacturer is setting the prices that may be used in all offers and the actual selling price. So it's the offer price and the selling price. Acronyms that you hear sometimes like MSRP or SRP, that's manufacturer's suggested resale price or suggested resale price. They have no teeth. They're just that. They're suggested prices. It's the price that appears on a bag of Frito-Lay potato chips. It's the price that appears on a sticker for a car. There's generally no teeth. They're just a suggestion. If anything, they kind of provide an implicit upper bound on pricing. Although in times of shortage, I've seen situations where sticker prices, dealers will charge more than sticker prices on cars and get away with it. Where the teeth are for minimum resale price are MRP, minimum resale price, sometimes called UPP for unilateral price policy, we don't care like that because all our policies are unilateral. I'll come back to that. And EMRP, if companies are only interested in controlling electronic prices, meaning online prices and prices through social media or whatever, then they do an EMRP for electronic minimum resale price. The other variant, which is everybody seems to talk about. In fact, they often use the term MAP for minimum advertised price when they mean MRP and/or MAP. But strictly speaking, MAP is minimum advertised price, and it just covers certain offers. And what I mean by that is it will cover, in the case of brick and mortar, any offer made outside the store, meaning things like direct mail, television, billboards, any online, and the like, but nothing in the store. It does not cover displays or signage within the store or price tags. And it's just the offer price. So when somebody has a MAP policy, the reseller is allowed to vary at the cash register. And in the online context, the MAP will cover the product page and the in the cart price, but does not cover the checkout price. So there can be discounts that are below that. And then variants on MAP are IMAP, which stands for Internet Minimum Advertised Price, or EMAP, Electronic Minimum Advertised Price. All these variations are important, and you know, why would you choose one over the other? And it comes down to a question of control. How much, given your product, how much control do you want to exercise over the price? Do you want to control the actual selling price, or are you only interested in the offer price? Well, one reason people are only interested in the offer price is you have factors out there like Amazon, relevant both the B2C and B2B market, where Amazon will scrape prices, and it tends to be a follower. It will lower its prices wherever it finds a lower one. Well, scraping technology is terrific. It can usually see the offer page or the product page, and it can see the in the cart price, but it can't see the checkout price. So for a lot of people, just doing MAP and allowing the price variation works just fine because it is more difficult, unless you mystery shop, to see what the actual purchase price is, and that'll work. Others just say, nah, we want to go for the whole enchilada here, and we want to control the actual selling price. So penalties for these policy violations, you're going to have financial penalties, usually the loss of accrued trade funds with no additional accrual during a penalty period, the loss of an implicit discount, one of my favorite. You say implicit in our price to you is a 10% discount for following MAP or MRP. If you vary from that, you lose the implicit discount. So during the 30, 60, 90-day penalty period, your price of your product or your purchase price from us has gone up by that lost discount. The loss of product access, you can either have a complete cutoff, you can have a allocation percentage. This came up particularly when we had product shortages after COVID, where rather than cutting somebody off for violating, we just say normally you'd be allocated 100, you only are allocated 50 to punish you for your pricing misbehavior. You can cover the loss of access. It can be at the SKU level, it can be a product family. Sometimes product family makes more sense because the SKU level might be the orange one and the violator is still getting the green one, the purple one, the yellow one. So it could be a SKU, product family, or it can be everything. You can combine these to have a financial penalty plus access loss, or you can offer them as options that are up to the manufacturer, because some people, they may be stung more by losing discounts. Others may be stung more with loss of access. And needless to say, since most manufacturers have both direct customers, that is resellers or end users that they sell directly, resellers they sell directly, but they also have indirect customers, meaning ultimate resellers that buy from wholesalers. Well, if you're going through wholesalers, you can't really have financial penalties. That generally doesn't work, but you can require the wholesaler not to sell to somebody for a particular period of time. And then the ultimate penalty is the loss of product access, again, on a limited basis or overall. Now, the reason I say ultimate penalty is most companies don't want a one strike and you're out environment. In fact, it's usually the salespeople that push back heavily on that because they don't want to see the sales go down and then consequently their commissions or their bonuses go down. So most of the policies we do are either 3 strike and you're out or 4 strike and you're out. With the first strike being we notify you of the violation, you have a period of time, 24, 48 hours to take it down. If you take it down, nothing happens to you, but you've accrued 1 violation. The second violation would be more substantive, like the loss of financial or like some sort of financial penalty or cutoff for usually a finite period of time, 30, 60, 90 days. You want something with sting. You don't want to shoot them in the head till they're dead. So you want some sting. And the question is, what's the average inventory? If somebody's got 45 days of inventory and you cut them off for 30 days, there's no sting. But if the average inventory is 30 days and you cut them off for 45, there's some sting. And then the ultimate penalty in a 3 strike and you're out scenario would be we pull the plug until further notice on a SKU, product family, or everything. In a 4 strike and you're out scenario, the 3rd strike looks more like the second. There's just more of it. If the second has a 30-day penalty period, the 3rd might have a 60-day or 90-day penalty period, and then the 4th is the ultimate one. And then we get to the final question, which is reinstatement. Most of our clients say, wait a minute, I don't want to cut people off. I'm in the business to sell product. Well, the answer is, even if you cut them off ultimately, you can reinstate them anytime you feel like it. So if you think they've learned their lesson, you want to turn them back on, you turn them back on. You do not have to turn everybody back on. You can pick and choose your customers. Now, you got to be careful not to form an agreement. So you don't say, well, if you promise to be good, we'll turn you back on. No, you don't say that. You just say, we're turning you back on. Next slide. So the legal standards for pricing programs are pricing agreements. Remember, you can do this either by agreement or policy. We like policies a whole lot better. But pricing agreements are judged under the rule of reason at the federal and state level. And I'll come back to that. It's a manufacturer-friendly standard, but it's still application of the antitrust laws. For MRP, most states, like 45 of them, apply the rule of reason. 5 states, though, it is always illegal or unenforceable to set minimum resale prices. This is the actual selling price by contract or by agreement. And those 5 states are California, Illinois, Michigan, Maryland, and the one place where it's always unenforceable, not illegal, but unenforceable, is New York. So if you're going to do an MRP, you've got no choice. You've got to go with unilateral policy. But unilateral policies, because they're not covered by the price fixing laws. Remember, Section 1 of the Sherman Act requires a contract, combination, or conspiracy. Unilateral policy is an announcement. There is no agreement. So you're outside the price fixing laws. And it's the first choice for MAP or MRP programs because it's simply much more flexible. Next slide. So I already alluded to this. Why are unilateral policies treated differently? Because they lack the contract, combination, or conspiracy requirement of the Sherman Act. Next slide. Go back one. Okay, so where does this rule of reason come from? The rule of reason is, again, Section 1 of the Sherman Act. In red, it says every contract, combination, or conspiracy. Next slide. Well, the Supreme Court, and this is one of the reasons I love the law, the Supreme Court says, well, every really doesn't mean every. Really? No, it doesn't. So there are 2 ways of antitrust treatment. The first is something we call per se illegality, and this relies on negative assumptions. In other words, there are certain practices that are shown or assumed to be so bad that there is no justification for them. And in general, horizontal price fixing is one of those. That is when manufacturers get together in a smoke-filled room and fix prices. That is just illegal on its face. There's no justification for it. Okay, so per se treatment, there are assumptions that things are so bad they can't be justified. They're illegal on their face. Rule of reason, where the law has been trending for the last 50 years, things that historically were per se illegal have been moving to rule of reason. This requires demonstrable economic effect. Next slide. And the reason it's favorable to manufacturers is because there's a presumption of legality. So you start out, the law assumes it's legal, and it's up to the challenger to show otherwise. And there's a balancing test that takes place, pro-competitive benefits versus the anti-competitive detriments. and it gives the party that put the restriction in place an opportunity to defend. So what this means, bottom line, it's harder for plaintiffs to win rule of reason cases and expensive. So these plaintiffs' class action lawyers and other kinds of people tend not to bring them because it's not like shooting fish in a barrel. Too expensive, too time consuming. So that's a good thing. So even though, to recap, even though we have things where certain forms of pricing agreement, principally all MAP agreements and MRP agreements in 45 states, are judged under the rule of reason, that's a good thing. It is still better to do these things by unilateral policy, because you don't even have to go through this sort of analysis of rule of reason. It's simply outside the Section 1 of the Sherman Act. Next slide. Okay, let's go back to this analysis again. I'm talking about, this time, price to resellers. So same diagram as before. We talked about the total pie on the left. But now the determination of this total value in this example, $63 million, how is it determined who gets what of that between the reseller and the manufacturer? Well, it's determined by what I call the cut, and that is, what is the price that the reseller pays for the product? Net of all discounts, allowances, rebates, you name it. So to the extent that the manufacturer can move that up and down by controlling the acquisition price, it can make sure that there's, from its perspective, that there's an equitable division of the amount of value that's in there. We've certainly seen situations where this diagram looks a little bit different, and that is the reseller compensation is huge. The manufacturer compensation is fairly small, and most manufacturers say that's not that's objectionable. That's problematic. So if you think about it, we're going to dig deeper into this issue of the reseller net price. But if you control the resale price with a policy in the size of the pie, and you also as a manufacturer control the cut, then as far as your resellers are concerned, you're telling them what their margins are going to be. And that's a good thing, because you want them to have sufficient margin to provide all the services you look for that help differentiate your product. But it also controls so that their margin isn't much bigger than what you believe it should be. Okay, next slide. So one concept with respect to trade funding, so these are the discounts, allowances, rebates, or whatever, is to allocate them based on the value. And by value, I mean recognizing reseller value by their degree of alignment with the manufacturer objectives. So those resellers are out there that are behaving the way we want. They're doing things. If we're looking for greater penetration, they're working hard at that. If we're looking for greater volume, they're doing that, or whatever. But aligning your rewards with what you want them to do and your own objectives, obviously. So this is something called pay for performance. And I think pay for performance has been more common in the consumer area for a long time. In the industrial area, it's probably been the last 20 or 30 years where it's getting more prominence. But the idea being, hey, if you perform well, I value that, and I will compensate you better than your other resellers who don't. So I can provide incentives and rewards for both financial and non-financial level. Next one, John. So if you're doing account-specific pricing, that is, you're rewarding not uniformly, but on a differential basis, this leads to economic discrimination. So you've got the issue of economic discrimination, which, from a legal point of view, is illegal under certain circumstances. Next slide. So economic discrimination triggers the Robinson-Patman Act. So true or false? Under Robinson-Patman, all customers must be treated the same or fairly and equitably in pricing and promotional benefits. Next slide. The answer is false. Only competing customers must be treated alike unless there's a good reason to differentiate. And we're gonna drill down on this in a minute. But this concept of fairly and equitably as legal standard simply doesn't exist. It's not in the statute. It's not in any cases. It doesn't exist. It's a construct useful usually for business purposes when business people are told, oh, we've got to treat them fairly and equitably. Well, again, that doesn't exist as a standard. It's okay as kind of a general guideline, but if you really want to drill down, it doesn't exist. In fact, it's been our experience that often business people are much more conservative than what the law allows in this area. Next slide. So since I only have to treat competing customers the same, what's the definition of competing customer? It's they chase the same purchaser. I mean, think of it as a Venn diagram. If there's a lot of overlap, they're chasing the same purchaser. If there's a little bit of overlap, they probably are not. And you could have natural divisions. So somebody put aside the internet for the time being, or electronic selling. You can have a natural division, meaning you've got a reseller in New York and got another one in California, and they just sell in their local markets. They don't compete. Can you charge them different prices all day and all night? Alternatively, if you don't have natural divisions or not the ones that you want, you can introduce contract or policy-based ones. Next slide. So these are non-price restrictions that are useful to support channel goals. They're often ignored by manufacturers, particularly in the consumer area, but they're very useful and often used in the industrial area. Smart consumer manufacturers are coming onto this. So for example, let's assume I'm a consumer manufacturer and I've got a pricing policy. I can restrict what resellers I allow to sell online. I can restrict, it's getting down to restriction types at the bottom. I can tell them not only where they can sell, but what they can sell and to whom they can sell. So I can control the amount of overlap, and therefore where I have to do more or less uniform pricing, but I also avoid channel conflict. And so, as it says, this helps facilitate economic discrimination and helps control price erosion and channel conflict. So remember, and this is all judged under the rule of reason, I can tell my resellers to whom they can sell and who they can't, where they can sell and where they can't, and what they can sell and what they can't. There is no legal requirement that all your resellers are allowed to resell all your products. Next slide. So there's two kinds of discrimination that Robinson-Patman worries about. There's price discrimination, promotional discrimination. Price discrimination is always associated with the buy price of the reseller. Or in cases, and we're not going to go into this detail, where the manufacturer sells directly to end users. So I'm a manufacturer of fasteners, and I sell them to Ford, and I also sell them to General Motors. That's also covered by Robinson-Patman. We're not going to go there. More common is the reseller thing. So again, we're going to focus on that. In this case, the manufacturer is selling to a reseller. It's the buy price of the reseller that's covered by price discrimination. Next slide. And the law says competing customers of goods, and I'll come back to that in a second, must receive the same prices unless at least one defense is present. Availability. So we offer a prompt payment discount, 210 net 30. Some take advantage of it, they get the discount, they pay less. Others don't take advantage of it, they wind up paying more. That's discriminatory on its face, but it's lawful because it was something available to everybody. They just chose not to use it. We'll put aside for the time being a very common issue, which is customers who take the prompt payment discount but don't pay on time. That's illegal, but widely done. The second is cost justification. If it costs me less to serve a particular customer, whether an end user or reseller, I can reflect that in my price. So somebody who orders a gazillion times little bitty orders versus somebody who places big orders that are more efficient, I can reflect that in the difference in my price. Changing conditions is another one. So changing conditions are, I've got a warehouse full of products that are about to spoil. They're going to be out of date. I've got obsolete products in the electronics business or whatever. I can offer discounts to clear that inventory, even if somebody the day before paid the full price. And the last one, which is something a lot of people focus on, is meeting competition. And that is I can lower my price to meet or beat a competitive offer. Now, we'll come back to that in a second, but I just want to touch on this issue of Robinson-Patman only applies to goods. It does not apply to services. So while there's some state statutes, like in California, that apply to service discrimination, that is service price discrimination, at the federal level, it doesn't exist. So you service providers have a lot of flexibility in terms of charging different prices. The goods people, not so much. Meeting competition, there are three types. Micro, macro, gun at the head. Micro is meeting a specific competitive offer. Macro is if a particular discount structure is standard in the industry, like volume discounts for 1,000 units, 5,000 units, 10,000 units, and so on, even though I can't justify that from a cost perspective or whatever, if I need to do it in order to be competitive, I can do it. The last one is gun at the head. Gun at the head is where a very powerful customer says, my way or the highway. Nobody likes to talk about this, but you've got some flexibility in this regard as long as you legitimately believe that you're going to be penalized unless you play ball. But part of the problem, we've seen this, is abuse. And by abuse, if this is made too readily available, you've got salespeople with every order they write where they're looking for a discount, that's meeting competition, meeting competition, meeting competition. Well, after a while, it just isn't. So you got to be careful about wear out. And it should only be applied in situations where it's legitimate to meet competition. Alternatives that you also keep in mind to avoid abuse. One is share the pain. Where's it written that when a reseller comes back to the manufacturer and says, in order to make this deal, I need a discount or whatever? Where's it written that the manufacturer must take the whole margin hit? What's wrong with saying it's perfectly legal? Look, reseller, we'll cut our price to you by X, but we expect you to cut your price by Y. And if and only if you show us that that was the price that went to the end user and you made the deal, will we give you a rebate or we'll do whatever to provide our discount. In other words, share the pain of the discount. And then you can do mandatory pass-throughs. Okay, fine, we'll give you a discount, but you're required to pass it through penny for penny to the end user or to the customer. I've seen some data that it's usually company specific, but it'll say that in many cases, when resellers ask for so-called meeting competition discounts, they use it to preserve their own margin, or they put it in their pocket and they don't pass it on. It is lawful to require them to pass it on. Next slide. Promotional discrimination, remember, when you're dealing with resellers, it only, price discrimination focuses on the reseller's buy price. This focuses on the reseller's sell price. What does the reseller do, effectively, what does the reseller do with the product once it has it? That's probably a better way of stating it, because the discount obviously goes to the reseller's acquisition price. But where price discrimination is focused on how the reseller buys, promotional discrimination is focused on how they sell. Next slide. Promotional discrimination is allowances and services must be functionally available on a proportionally equal terms to competing customers of goods, unless a variation is necessary to meet competition. So we've got some different concepts here. We've got functional availability. What does that mean? It has to be usable or attainable in a practical sense by all competing customers. So you can't have some things that are outlandish. And proportionally equal terms, it turns out that's where there's a tremendous amount of flexibility, and we'll come back to that. And again, we have the standard of competing customers. Here, because of a drafting quirk, your only defense is meeting competition. You don't have the other ones that you do with price discrimination. Next. So promotional equality, I said this is where your flexibility is. You can allocate promotional dollars based on purchases. Buy a case, get $1. The more you buy, the bigger your discount. That's perfectly okay, at least in aggregate dollars. You can do it on cost of the reseller. We'll pay 50% of the cost of a full-page ad. The little guy advertises in some medium, it's a small town kind of thing or much more restricted. It's $10,000, so we pay half the cost. The big guy advertises in a large medium that's very expensive. The cost is $100,000. We pay $50,000. That's perfectly okay. But the big one, where all the flexibility is value to the manufacturer. I can place a value tag on certain kinds of performance. One of my favorite examples is, suppose I'm a plumbing equipment manufacturer or plumbing fixture manufacturer, and I decide the way to really sell my products is if my dealers each give me a 200 square foot showroom. And for that, I will give them a 3% rebate on everything they buy from me. They give me those 200 square feet and they have certain products in it and whatever, because that really works for me. So it's an example of alignment, and it's an example of what they do with the product once they have it. So it's promotional and it's a value to me. Now, it may turn out that providing that particular showroom is, the cost of it is much less than that 3% rebate they're going to be getting from me. Who cares? I can still do that to reward them because it's that important to me. So this value tag issue is widely used. Now, if all I did, by the way, was say, hey, give me a 200 square foot showroom and I'll give you a 3% rebate. And it turned out there's some little guys out there whose floor space, they don't have 200 square feet. If I just did that, I'd have a Robinson-Mattman violation. So I usually need to offer alternatives. But again, I can place a value tag on those. So I can say, give me a 200 square foot showroom, I'll give you a 3% rebate. Hang up a poster that says, buy my product, I'll give you a one-time payment of $50. That's it. So proportionally equal. And one last thing about promotional discrimination. When I say it's associated with what the reseller does with the products once they have it, those are things like display allowances, the showroom example, whatever they do with the product, how they advertise it, so on and so forth. Next slide. Now, when I've got wholesalers or distributors involved, meaning that they're between me and the ultimate reseller. Wholesalers and resellers, by resellers I mean the ultimate reseller. So let's take the example, wholesalers and retailers don't compete, so I can charge them different prices. By definition, they don't compete. Although these days a lot of lines are blurring, which may change that, but at least historically they have not competed. And the promotional discrimination is a little bit different though. If you're direct buying and indirect buying, ultimate resellers compete, they've got to receive proportionally equal promotional benefits. So in other words, if I've got a retailer that buys from a wholesaler and it competes against a retailer that I sell directly and I give promotional goodies to the direct buyer, I've got to make sure I get some promotional goodies to the indirect buyer. Now, most companies ignore this, but it is a requirement. Now, I can do that by providing benefits directly to the indirect, figuring out a way to do that, like a rebate or whatever. I can furnish benefits to a wholesaler with a mandatory pass-through, telling them they've got to pass them on, or I can find another means. Next slide. I can also use what I call non-price goodies. Non-price goodies are not covered by the Robinson-Mattman Act, so I can reward behavior that I like by maybe giving the favored resellers who are doing a great job. I give them early new product access, so they get the new product before anybody else does. I can offer unique or special packs for them. I can provide enhanced support, such as maybe they get order fulfillment preference over others, and allocation preference. They may have dedicated salespeople rather than just calling in orders or sending them in by email or whatever. But this could also be a powerful tool. Next. So let's talk about some programs here. We've only got a few minutes left. We'll probably run over anyway, but bear with me. One thing we see that's very common are tiered programs, and this is an all or nothing tiered program. So here we classify our resellers or ultimate customers, but we'll stay with the reseller example, into three types: gold, silver, or bronze. So for the bronze people, we have, they only have to provide base performance for us. They maybe have to purchase a minimum volume. In other words, in order to sell them directly, they've got to purchase, no less than $500,000 a year or whatever the number is. And they have to pay their bills on time. Maybe that's the only requirement for bronze. And for that, they get, and I'm making this up, they get a 10% discount off list. If you go to silver, they're doing everything bronze does. Plus, we have a share of shelf or share of warehouse minimum that they have to attain. A third of their products in this category or more have to be our product or whatever. And they have to comply with our policies. And for that, they do all those things. They get 15% off list. And then gold, they have to do everything silver does, plus they have certain growth incentives or growth requirements. They have to carry our full line, and maybe they have to meet a certain contribution margin level. And for that, they get, let's say, 18% off list, whatever the number is. And what makes this work lawfully is that you notice none of this stuff, except for the minimum volume for bronze, which is okay because it's just the initial threshold that will sell directly. But none of these are really volume-based. They could be, but they're not volume-based. So what makes it work from a legal point of view is a lot of fluidity within the pyramid. So if bronze starts doing these other things for silver, regardless of its size, it can get silver prices, and so on and so forth. Next slide. One of the problems with the last one is it's all or nothing. You have to meet all the criteria at a particular level or you get none. You don't get the benefit. Also popular tiered programs are points-based ones, and this is modeled after something that Cisco does, Cisco the network provider. So here, In the example, we have the performance starting at the bottom. The performance reseller has to get between 80 to 120 points, performance plus 121 to 150, premier reseller greater than 151. And points are earned based on the volume that they purchase, growth, their brand support, would they merchandise properly, would they otherwise comply with our policies, and maybe other criteria. And what I can do with these various criteria is I can make some of them mandatory. So everybody's got to do certain things like pay your bills on time. But I can also weight them. If there's some things that are more important than others, I can grant more points by weighting some of these criteria. And as a result, again, you have fluidity within the pyramid, but here it's not all or nothing. So I can earn my way to be premier by doing everything or a handful of things that get me to 151, whatever I want to do. So this kind of program is very popular. Next slide. Another alternative is the a la carte approach. This is based on a real example we did for a client, and it uses a market development fund. And by market development fund, this is a rebate based on certain characteristics. So in this particular client, let's assume they're in the cosmetics area, health and beauty area. The category base for shampoo is 2%. So you get a 2% rebate at the end of the year for everything you buy in this shampoo, of our shampoo products. But then we add tiered adders for each criterion. So depending on your level of performance, you can get an extra quarter point, half point, or full point. So your shampoo discount could go up to 3% or rebate. And the criteria for this, and these, by the way, much like the last example, these are weighted. You don't necessarily have to do all of these things, but there are certain things that will allow you to move up or move down. And some of the criteria that were used, your 3-year compound annual growth rate, your 2-year growth rate, the number of items that you carry, sales per item per store, number of displays shipped, number of displays per store, returns and allowances, whether we're the category captain, strategic alignment with what we want to do, the number of stores, sales per store, contribution margin, return on investment. So all of these were criteria, and what essentially you've got is a huge matrix. And then you rate everybody on this. Now, very interestingly, the way this turned out is you had some really big customers who should have been there, get to the top tier. They got the biggest discounts, like Walmart got there, terrific. They did it on a variety of criteria, one probably being volume and other kinds of things. But interestingly, there were a bunch of little guys that also got the top percentage discount. Now, their base is much smaller, of course. They don't buy like Walmart, but they got the same percentage discount that Walmart did. Why? Because they could do things that Walmart couldn't do, like they could give us exclusivity, and we were willing to pay for that. So we're the only shampoo on the shelf. Or they could do other kinds of things or whatever. So from a legal point of view, this is absolutely bulletproof because you had the little guys getting the same discount. But it made a lot of sense, and it rewarded performance. It rewarded, all of these things were in alignment with what the manufacturer was looking for. And by the way, it's not the biggest shampoo manufacturer out there. It is a number 2 or number 3 player, but this helped it differentiate what it was doing. It was very successful. Another one is loyalty incentives. I mentioned exclusivity before, but rewarding if we're the only product in this category on the shelf, or quasi-exclusivity, meaning that we have to be, you can't carry more than 2 competitive brands or something along those lines. Or you have to carry our full line or key assortment, and you reward for all these. Or we have to be your lead line, meaning that we're the first one that comes up on your website or in your catalog or whatever. Or lead lines defined by share, what we have as a share of the category or of your shelf or your warehouse. Next slide. One of my favorite, and we're just about done, is the Opportunity Fund. Now, we did this for a large electronics manufacturer to great effect. They had a market development fund that accrued at a certain percentage, which is pretty much the same for everybody. But they wanted to be able to have a slush fund to put extra dollars behind certain kinds of behavior. So we set up a discretionary fund, put some millions of dollars in it, and it was funded annually. It was available on paper to all resellers. In other words, we announced it to everybody. And then there were certain eligibility criteria that we'll come to. And it was available on a first come, first served basis. So once the fund was depleted, there was no more. And the eligibility criteria were, in other words, when a reseller would come to us, we'd say, okay, what's the opportunity and what's its magnitude? How important is it? What is the return on investment associated with it? Is it aligned with our strategic objectives, that is the manufacturers? Do we need to do something to meet competition? Is there an will this help build brand equity? Does the reseller conform to our policies? And this was a key one for this particular client. They wouldn't fund anything unless the reseller was making a contribution of one kind or another, financial or in kind. So as a result, this gave a lot of flexibility to allocate this stuff. And as a reality, how did it work? Well, the salespeople, particularly the big customers, would let them know about this and start talking to them first. So a lot of the money was gone before others found out about it. Well, too bad, it's still lawful. And so this turned out to be a very successful tool. Next. Well, the bottom line is that I know we've talked fast and we run slightly over. There's a lot of flexibility. There are a lot of hot issues out there. It's not necessarily what the reality is not necessarily what a lot of people believe. And as I said, you can do a lot of things. You just have to be smart about it. John, I'll turn it back to you.
Gene, is it okay that we take Q&A? I mean, given the
Yeah,
crowd,
sure.
I'm about to open up everybody's microphone, and if they've got Q&A, then please speak. I'd like to ask the first one. One of our chief pricing officers couldn't make the session, and he just took a new role in specialty chemical. And he asked the question, the topic I'm very curious to ask Gene about is one of these, one of them has to do with distribution pricing. To what extent can a company legally set guidelines for what a distributor can sell their products for? Now, this is in specialty chemical. And it follows by saying, I'm being told by people in my industry that distributors have total latitude, but we also have an issue where we will get out products designed into a project, and then the distributor, the subcontractor goes to quote a price for our product so high that they have to go back and get a change order to get our product taken out. Did that make sense?
Ooh. Well, okay. It seems that we address this when talking about setting resale prices. So as far as distributors are concerned, you can lawfully tell them what they can resell your product for. And most common is setting a minimum price. So you don't want them to go below it, but you could set a maximum or an exact price, or you could set a range. We've done that in situations where, like, again, post-COVID with the supply chain issues, some clients were concerned about price gouging. And so we set maximum prices for our products. You can do that. We can do ranges. We can do minimums. So you can actually tell them what they can charge and what they can't charge. And it sounds like there you've got the behavior seems anomalous. I mean, if they can get away with charging a super high price, fine, that goes into their pocket big time. But the fact that then there's change orders to get the product out and we're losing the sale and everything else, obviously it's all behavior we don't want. And I would say we could put pricing restrictions on what they can do. And it's lawful if you do it the way that we described it.
Okay. Anybody want to come off mute and ask another question?
I have a quick question. Unfortunately, I was a couple minutes late. Is there a recording? Because I'm really going to want to watch the first 5-10 minutes. Eugene, this was fantastic.
Absolutely. Yeah,
really,
there's a recording
really,
and it will be coming up next
you know,
week.
like you got me thinking about some things I hadn't thought about in a long time and in some different ways. So this has been super, and I'm just really excited about it. So I'd love to catch the 5-10 minutes I missed it at the beginning. Thank you.
Or alternatively, I'll be glad to talk one-on-one to anybody about this stuff. Just not an issue.
I may reach out to you just on a personal note just to get to know you. So
Okay.
Thanks.
Outstanding. Are there other questions?
I've got two questions related to MRP MAP. If you have a unilateral MRP MAP policy, is there any risk of if you're not enforcing it, i.e. there are violators out there, but you're not necessarily strictly enforcing it? And then also related to MRP MAP, what recommendations do you have for penalties for violating the MRP MAP when the violator has significantly more market power, i.e. Amazon is significantly more important to my business than my business is to Amazon, right? And they can shrug their shoulders at my violation and go, whatever.
Okay. Well, in that regard, let's take the first one. A common issue is people not enforcing their policies. And two things happen. From a legal point of view, the fact that we're giving some people a pass can support the notion that we have an agreement on price with the ones that we're giving a pass to, or the ones that we're not. Now, that's a presumption. You've got to show it. And remember, even if you have an agreement in the MAP context, it's not illegal. It's a rule of reason. It can screw up your MRP. We don't, quite frankly, there's almost no challenges in this area. So the legal stuff, it's important, but it's not what's driving this. What should be driving it is from a business perspective. If you don't enforce the policy, you don't have a policy. Because what's going to happen is the little guys in particular are going to say, why should I follow this when it's clear this guy's getting away with murder? They already believe that you're favoring Amazon over them anyway. But this just supports it. So if you're not going to enforce it, the best answer is don't do it. Just don't do it. Put your energy into other kinds of things, but you need to enforce it. But let's talk about the second one. So we've been on this road many times with Amazon, and Amazon, there's no question, is a 10,000-pound gorilla. But for that matter, so is Walmart, so is Grainger and others. But in any event, it's interesting with Amazon. I'll give you a real life example. It was a small company, it's a big company, in the clothing business, one of our clients, that we did an MRP policy for. And they sell only high-end clothing. So they only sell through department stores like Nordstrom and Saks and whatever, and specialty stores. But they decided to sell Amazon 1P. So they're selling to Amazon, then Amazon's reselling for its own account. And I asked, for some reason it's a big company, but I've always worked with the CEO. And I said, how's Amazon doing? And he said, they're fine. They're fine. They're holding price, not a problem. But one day he calls me up and he says, Amazon's discounting. What should I do? And I said, well, you got a choice. Either you don't do anything about it and your policy is going to go down the tubes because it was working elsewhere, or you enforce it against Amazon. And I know that there are millions of dollars at issue. Amazon's a key customer. And he said, I thought you'd say that. So they cut off Amazon. And then Amazon did what I've seen it do forever. For big brands like this one, for small brands. We had the same thing happen for a company we work with that makes French press coffee makers. Most people have never heard of the name, but they make nice products. But in any event, they did the same thing. Amazon within 30 days comes back begging for the product, begging. So you said you're more important, they're more important to you than you are to them. I'm not so sure, because what drives Amazon is they want to be all things to all people. And they go absolutely crazy if they don't have every brand. Now, of course, the bigger the brand, the more bargaining power you have. But they want all the brands. They want everything. I'm reminded of the old, this undoubtedly dates me, slogan that Sears used to use. Sears has everything. Well, that's what Amazon wants. Amazon wants everything. So we've never seen it not happen where Amazon gets cut off, they're back begging for the product. Now, I'm not suggesting you play chicken with them either, because it's your brand at issue, but I suspect you've got more bargaining power than you think you do. And unless you enforce it with Amazon, Amazon's going to erode those prices, and you're going to have trouble getting them in other places, and you're going to have the same complaints with the traditional resellers going nuts and saying, I can't make any money in your brand, give me more trade dollars, or do other kinds of things. So you got to put a stake in the ground. Now, you may be able to control it in some ways, where maybe you don't sell Amazon everything you got. Maybe you restrict, or maybe you do special products for them that you don't do for other people. I mean, there may be other ways to contain it, but I think you can't ignore a big player like that. Otherwise, I'd say if for business reasons or other kinds of reasons you just simply can't do it, don't do a policy. You're wasting your time and money.
Thank you.
Okay. Easy for me to say, though. I don't have P&L responsibility.
Yeah, got it.
Are there other questions on the line? If not, Gene, I've got in watching this, I'm seen it a variety of times. I am endlessly fascinated each time that you do this. And I'm wondering if we should be looking at a Gene Zelek as much as a lawyer as a strategy advisor, and when you say that you're working with a number of companies, how much of your work is being done specifically when it comes to your legal capacity, and how much of that is more strategic in nature in terms of what to consider when getting into some of these situations?
Well, they're so interrelated, but particularly in the area of MAP and resale price. Since I've done so much in the area, I could just strictly stick to my legal knitting. But because I've seen other kinds of things, such as what we were talking about, some of the practical sides of it and things like that, I usually can't help but talk about that. Now, that doesn't mean that I'm terribly knowledgeable in the business area. I mean, I've done this stuff for a long time, but I think the two are really interrelated. And I don't think you can, I've certainly have encountered some people who say, just tell me what the law is. Well, fine, I'll tell you what the law is. But don't you want to know what your options are? Don't you want to know what the risks are? And, part of it if you're being a good lawyer, you never say typically yes or no, or particularly no. It's usually what you're proposing is rather risky. If you do these couple of things, you'll ameliorate the risk. And then, of course, from a business point of view, if I see something that seems to be obvious or problematic, I'll raise it. That doesn't mean I know what I'm talking about, but I'll raise the issue and I'll say, have you thought about this? Kind of like being a devil's advocate. Have you thought about the implications of this? Because sometimes what I see business people do is, while they're focused on their immediate problem, they don't see the implications. They don't see the pebble in the pond kind of thing, where there's the ripples that go out and cause things. So you try to say, well, you realize what this may cause or whatever, and if that's okay, fine, and it may not happen. So I always like to try to provide fuller advice and that kind of thing than just say, oh, this is what the law is. And in fact, for me, it's far more interesting to be involved on the strategy side.
Well, Gene, thank you very much. Again, love to listen to you talk, the presentation and the opportunities and the possibilities that they present. So thanks again for your time, and thanks to the Chief Pricing Officer community and any of those that come from the legal profession who've attended today.